Good morning. I'm Ginger Powell. I'm with the Northwest Tennessee Workforce Board, and we are so glad that you're joining us today for our Virtually Speaking webinar series. Today, our topic is going to be brought to us by the EEOC Lead Outreach and Education Manager, Debbie Finney. And I just want to do a few little housekeeping things first. I want to mention our website. So if you've missed any of our Virtually Speaking webinar series previously, you can access all of those on our website. That's nwtnjobs.org. And so you can find all of our previously recorded webinars there. Also, throughout the webinar today, if any questions you have, you may enter those in our chat box. You should have a chat box on your screen. So just feel free to go ahead and add those questions there, and we will come back at the end after Debra's presentation to answer those for you. So I want to give you a little bit of information on Deb Finney. She's the Lead Outreach and Education Manager for the EEOC's Memphis District, which has jurisdiction over Arkansas, Tennessee, and North Mississippi. In this role, she provides education, training, and technical assistance to the stakeholders within her district. She is a collateral duty trainer on several national training projects and for the Office of Field Operations. Prior to becoming the Lead Outreach and Education Manager, she served as an investigator in the Little Rock area office for 23 years. She will be retiring soon, I found out today, later on in July. She has 41.5 years of service with the EEOC, so she brings a wealth of knowledge for us today, and we're just really excited to have her here. And with that said, I'm going to turn the presentation over to you.
Thank you, Ginger. Good morning, everyone. I'm really excited to be here. I am excited about my upcoming retirement, but I just have to say this has been a wonderful career, and I've still got several things I've got to do before I go. I'm doing lots of presentations and trainings before I go, so I'm not going out quietly. Thank you for being here today. I'm excited to talk to you about, kind of the latest things going on at EEOC and what we're focused on and what we're doing and sort of some of the common areas where we see charges continuously come in. We have been on telework for the past 2 years, and we're slowly getting staff back to the office. But one thing we learned with telework is that we could still do investigations, we could still do mediations, we could still do litigation. So it's been an interesting learning experience, as I'm sure it has been for many of you and your organizations. So I just want to start real quick, just in case anybody doesn't know who the EEOC is. We are a neutral federal fact-finding agency. Our vision is respectful and inclusive workplaces with equal opportunity, equal employment opportunity for all. And our mission is to prevent and remedy unlawful employment discrimination and advance equal opportunity for all in the workforce. So what do? We are the agency that's responsible for enforcing the federal laws that make it unlawful to discriminate against a job applicant or an employee. We accept charges of employment discrimination. We investigate those charges. We mediate. We conciliate. After we have found a violation, we engage in a period of conciliation. If that conciliation is not successful, we litigate. And then what I do is educate. We educate our stakeholders, the public we serve, because we feel that by excuse me, education, it's the key to prevention. And so when people know their rights and when employers know their responsibilities, that's our way of addressing discrimination on the front end. Where are we located? Well, we have 15 district offices across the country, and in each district, there's also field and local offices. The Memphis district office is, of course, headquartered in Memphis. Delner Franklin Thomas is the district director, but currently is acting in a headquarters position as the director of Office of Field Programs. So she's over all the field offices in the country right now. Edmund Sims is normally our deputy director, but he is acting as the district director for the Memphis district. And then Faye Williams is our regional attorney. We have 2 additional offices. We have one in Little Rock, the Little Rock area office, and Bill Cash is the area office director there. And then we have an office in Nashville, and Philip Bornfield is our area office director there. Sorry for the noise, y'all. Important contacts in the Memphis district. Here's my information. If you have any questions and you don't get, you don't want them answered here, or you have a specific situation that you want to ask me about, there's my email, Debra Finney, debra.finney@eeoc.gov, and there's my work phone. I will be off all next week, though, but I'll be back in the office after that. And our mediation coordinator, oftentimes individuals may receive a charge and they have questions about, should I participate in mediation or not? Jimmy Jones is our alternative dispute resolution coordinator, and I've put his information on this slide as well, jimmy.jones@eeoc.gov, and his phone number. And I will also send this presentation in a PDF format to you all so they can disseminate it if they'd like, and you would have this information. So what laws does the EEOC enforce? We enforce Title VII of the Civil Rights Act of 1964, the Age Discrimination and Employment Act, which prohibits discrimination against individuals who are 40 and older, the Americans with Disabilities Act of 1990, and the subsequent Amendment Act in 2008, the Genetic Information and Non-Discrimination Act of 2008, which we call GINA, the Equal Pay Act, and then the Rehab Act of 1973. Rehab Act of 1973 is like the ADA, but it solely applies to federal employees. What are the protected bases? Basically, all of those laws I just listed prohibit employment discrimination based on race, sex, which includes pregnancy, sexual orientation, and gender identity, religion, national origin, age, 40 and older, color, disability, and genetic information. So when I mention a protected basis or protected category, that's what I'm referring to. Those things: race, sex, religion, national origin, age, color, disability, genetic information. Covered employers, basically everyone. Private employers, government agencies, labor organizations, employment agencies, staffing companies, apprenticeship and training programs, and protected individuals can be employees, job applicants, your temporary or seasonal workers, part-time workers, former employees. And you may ask, how is a former employee protected? Someone may discriminatorily, give a bad job reference, or discriminatorily contest an unemployment claim. So that's how a former employee could be covered. And then undocumented workers. What exactly is employment discrimination? Essentially, it's when a person is treated differently because of their race, sex, again, pregnancy, orientation, gender identity included, color, religion, national origin, age 40 and above, disability, or genetic information. Here's some examples of discriminatory practices. Again, not a list that's all inclusive, but it's illegal to discriminate in any aspect of employment. From the moment when a person, a job is advertised and you're recruiting, all throughout the employment process, through the employment life cycle, if you will, up until they leave, and even after, as I described, how a former employee. But it also includes failure to accommodate, the requirement that there be accommodations for disability and religion, and, anything that can happen in between. Also includes harassment on any basis, on the basis of race, sex, religion, national origin, age, color, disability. Any of that is covered. Retaliation against an individual for filing a charge or participating in an investigation. And then denying employment opportunities to someone because of their marriage to or association with an individual of a particular race, religion, national origin, disability, that type of thing. Harassment. Harassment is an area we continue to see a significant number of charges being filed. And, over the years, Years ago, we used to solely talk about sexual harassment, but that is certainly not the only type of harassment charges we get. What is workplace harassment? Essentially, it's any unwelcome, and that's key, it has to be unwelcome, verbal or physical conduct that's based on any of those protected categories that we talked about. And it occurs in the context of work or work-related activities. It becomes unlawful when you have two ways it can be unlawful. If you have to endure the conduct and it becomes a condition of your continued employment, and we call that tangible action type harassment, and the conduct is severe or pervasive enough to create an environment that a reasonable person would consider intimidating, hostile, or abusive. By far, the most significant number of harassment claims we get are claims surrounding a hostile work environment. The tangible employment action harassment primarily applies to sexual harassment, and that's that we used to call it quid pro quo, something for something. If you don't sleep with me, I'm going to fire you, that type of thing. But by far, hostile work environment is the most frequently filed harassment charge. Offensive conduct may include, but certainly not limited to, jokes, slurs, epithets, name calling, physical assaults, threats, intimidation, making fun of, insults, put downs, those types of things. It can occur in a variety of circumstances, including but not limited to. The harasser can be the victim's supervisor, a supervisor in another area, an agent of the employer, a coworker, a non-employee. So essentially anyone can be a harasser, right? And the victim can be anyone. It could be, a worker, it could be a customer, could be subjected to harassment by one of your employees. It could be a contractor working at your facility, subjected to harassment. And it can occur without economic injury to or resulting in the discharge of someone. You also do not have to show psychological harm. Years ago, you had to show that you were, actually psychologically harmed by the harassment to prevail in a claim, but that has changed. We say employers should prevent and correct unlawful harassment. You should always clearly communicate to your employees that unwelcome harassment will not be tolerated. Establish that effective complaint process. Make sure there's more than one path by which employees can report harassment. We see employers, well-meaning employers, will put together a harassment policy, publish it, widely disseminate it, and it contains just one path by which someone can complain. Let me give you an example. If you feel like you have been harassed, you can reach out to the HR manager, Bob. Okay, well, that's great, but what if Bob is on sick leave for 8 weeks? Or what if Bob is the person doing the harassment? So, we always tell employers, make sure you have more than one path. And what you see, a lot of times employers may say you can report it to HR, you can report it to any manager. Some employers have a hotline. Some employers have an email system that you can also go in and complete a complaint. So just make sure there's more than one path for individuals to be able to report harassment. Provide that anti-harassment training to your managers, employees, and then always take immediate and appropriate action when you find that harassing behavior has occurred. Let's look at liability for harassment. Employers can be liable for harassment in several different ways, and it depends upon the type of harassment being committed and who is involved in, who is committing the harassment. So it's automatic liability if you're looking at that tangible employment action, that quid pro quo. If a supervisor, if it results in one of those tangible employment actions, such as termination, failure to promote, higher wages, those types of things, because your coworker does not have that authority over you. Your coworker cannot tell you, if you don't sleep with me, I'm going to fire you. right? Only a supervisor can commit that type of harassment. And that's why there's automatic liability in that situation. Now let's look at hostile work environment, which is the most frequently filed type of claim. If the supervisor's harassment results in a hostile work environment, if the person doing the harassing is a supervisor, okay, then the employer is going to be liable unless it can show that it did, two things happen. One is that it reasonably took steps to prevent and promptly correct any harassing behaviors. And what that means is you have your policy, you have your procedures on how you're going to handle complaints, and you do that. You handle, when a complaint is filed, you take that prompt and corrective action. And that despite you having that in place, the employee did not take advantage of it, okay, without a good reason. What would a good reason be? You have this fantastic system in place and nobody knows about it. You haven't widely disseminated it. You haven't trained your managers and employees that you have this fantastic workplace harassment policy. You haven't, uh, we do it at work. We do annual notifications that, here's the policy and we have to sign that we, understand that there's this policy and we know where to find it. So if an employer has this great policy and doesn't do that, then an employee, they don't avoid liability because the employee has not unreasonably failed to take advantage of that if they didn't know it exists. Another example of an employer being liable despite having that procedure in place is that the employee, may know that the person that they're complaining about reports were made previously and the employer did not take action, or that someone utilized that policy and they were retaliated against for filing a complaint or making an allegation. So that would be a reason why the employee would not want to utilize that situation. Okay, so when you take it down to non-supervisory employees, your coworkers, your colleagues, or even a third party, the employer is going to be liable if they knew or should have known about the harassment and failed to take prompt and appropriate corrective action. What does that mean, knew or should have known? Meaning it was reported, okay? Or it was so widespread, everybody knew it was going on, or there may be someone wrote some derogatory, inflammatory language of a sexual nature in the bathroom and it's been there 3 weeks. We're going to say the employer should have known it's there, right? So that's what we look at. A level of control comes into place when it's not an employee. So if you have, say, a customer harassing one of your employees and you don't know who that customer is and that customer never comes back, there's not going to be much you can do about that, if you're not there at the moment when it's happening to put a stop to it. But let's say you have someone who delivers parts to your organization 3 times a week and they're harassing one of your employees. You have control over that situation. Excuse me, and that you know who it is that's delivering parts. You have a relationship with the company and you can handle that situation. So that's how we look at liability for harassment. I always have this tip for your managers and supervisors. Never, ever, ever agree to someone's request that you not do anything about it if they report any harassing or discriminatory conduct to you. If they report it to you and say, I just want to tell you, but I don't want you to do anything about it. And we know people do that, right? Your response should be, I'm legally obligated to do something. Because once you know as a manager or supervisor, then the company is, you're an agent of the employer and the company knows. And if nothing happens and that person comes in and files a charge, what are they going to tell us? The first thing they're going to tell us is, I told my supervisor about it. And, you have just created liability for your employer. So never, ever agree to that. We have a ton of resources on our website for employers regarding harassment, examples of a good harassment policy, all of that. And while it says it's small business, we do have a small business resource center. It applies no matter what size business you have. And I would say just go utilize that, check it out, get the tips and our preventive information, and you'll be good to go there. Disability discrimination. Despite the fact that we've been enforcing the ADA since 1992 and the Amendments Act since 2008, we still see a significant number of disability discrimination charges. It's very, the ADA, people are just sort of like, I don't know what to do with this. Fact situations change, but the very process, for accommodation, medical inquiries, medical exams doesn't change. And so when you get that basic understanding down, while it sometimes is difficult to figure out accommodations and things like that, following that basic process over and over really helps you. A person can show that they have a disability under the ADA in 3 ways. If they actually have a physical or medical condition that substantially limits a major life activity, or a major bodily function. If they have a history of a disability, such as, for example, they may have had cancer, but they're in remission now. They have a history of a medical condition that meets that definition. Or they're subjected to an adverse employment action by the employer, and the employer believed that person to have a physical or mental impairment, whether when they didn't. For example, someone may walk with a limp, and an employer decides not to put them in a position that requires them to climb a ladder because the employer feels like they are hampered in doing so because of their limp. Okay. Major life activities, caring for oneself, performing those manual tasks, seeing, walking, thinking, concentrating, breathing, speaking, all of those things are major life activities. Working. Major bodily functions was added in 2008 in the Amendments Act, and it covers functions of your immune system, special sense organs, normal cell growth, which would be like cancer, digestive, genitourinary, bowel, bladder, brain, respiratory, all of those are major bodily functions. Reproductive system, major bodily functions. So that sort of expanded, that widely expanded coverage under the ADA. The big area that we see under the ADA continues to be reasonable accommodation. The law requires an employer to provide a reasonable accommodation to an employee or a job applicant with a disability, unless doing so would cause significant difficulty or expense for the employee or for the employer. And that significant difficulty or expense we call undue hardship. A reasonable accommodation is any change in the work environment or in the way the job is usually done that helps a person with a disability apply for a job, perform the duties of a job, and enjoy the same benefits and privileges of employment as other employees. Reasonable accommodation might include, for example, making the workplace accessible for someone who uses a wheelchair, or providing a reader or interpreter for someone who is blind or hearing impaired. There's any number of accommodations and any number of things that could be required as an accommodation. I always take a moment to plug the Job Accommodation Network. It's a free service and they assist employers. We get so hung up in thinking how a job has been done. This is how we always do this job. That sometimes it's difficult to think outside the box in ways the job can be done that provides an accommodation to someone. And this is solely what they do, and they are fantastic at it. Their website is phenomenal. You can go and you can look up things by impairment, someone with a sight impairment, and they list all these different accommodations that they have come up with over the years. And then you can also request to meet with them and they can assist you. So free service. I always tell employers, keep that job accommodation network. Information available. Their website is www.askjan, Job Accommodation Network.org, and a fabulous resource for you if you need to, if you have a request for accommodation and you just simply don't know what to do at that point. So I mentioned that, an employer has to do a reasonable accommodation unless they can show an undue hardship. What is that? So we look at, it can be a financial difficulty for an employer, but it could also be a reasonable accommodation that's unduly extensive or disruptive, or providing that accommodation would fundamentally alter the nature of the operation of the business. So what do we look at when we're talking about financial difficulty? Basically, it's based on the overall operating budget of an organization. A small organization with, 18 employees may not have the operating budget of a multinational corporation. So we take into consideration those financial resources, the size, the needs of the business, to determine if that creates a financial undue hardship. So what are we talking about when we talk about unduly extensive or disruptive? Well, that is something that disrupts your operations, has an effect on your business operations. Give you an example. Let's say an employee asks for a flexible scheduling as a reasonable accommodation, and their request is that they have later morning hours. Okay. However, your business has to be open at a specific time for customers, and you have a limited number of employees trained to provide certain services. So requiring you to allow an employee to come in later hours would require either other employees to do extra work or leave you understaffed at key times. That would be unduly disruptive, okay, to your organization. And what are we talking about when we say it fundamentally alters the nature of your business? Let me give you an example. Let's say you are a movie theater and you have an usher. And honestly, we really don't see that many of those anymore, do we? But this usher has low vision, and this low vision has degenerated to the point now where the usher says, I need the lights in the theater to never be turned down below a certain level. Okay. However, we know that dim lighting and completely darkened rooms just are necessary for the theater to operate. Requiring that would fundamentally alter the nature of your business. So if any of those exist, that is a defense to providing a reasonable accommodation. And with any of those, you would still have to look to see, is there any other accommodation available that would alleviate that? So for example, with the usher, is there another position that they can be reassigned to that they could do? Something like that. The interactive process, we're real big on that. We frequently see employers kind of fail to engage in that interactive process. Employee says, I need a reasonable accommodation, or I have a lifting restriction of 20 pounds and I'm unable to lift this portion of what you have me lifting. Rarely does an employee come to you and say, pursuant to the Americans with Disabilities Act, I hereby request a reasonable accommodation. It's typically kind of common language. They come up and say, hey, my doctor says I can't lift anything over 20 pounds. Or, hey, I'm having trouble with this because of this medication I'm taking and I need adjusted hours, or whatever the case may be. That's typically how an employee reaches out and says, I need an accommodation. It's the first step in that interactive process. You should always make sure that your managers, your supervisors, HR people know this, they know how this works, but sometimes your first line supervisors, your first line managers, they don't understand it. And you need to train them to recognize when a request for a reasonable accommodation has been made. We see it over and over. A supervisor says, I can't do that. I don't, we just can't do that. We can't all, you have to do your job. and HR cringes when they find out. But make sure your first line people know how to recognize a request for an accommodation and what you want them to do with that. Typically, in a large situation, they don't want those first line people handling those requests. Make sure they know how to recognize and who to refer it to. And the ultimate goal of that interactive process is to find an accommodation that allows that individual to perform the essential functions of the job, which are the functions that the job exists for, right? If you're a data entry clerk, the essential function is putting that data into the system, right? Occasionally, you may be asked to pick up mail if none of the mail clerks are there. That's not an essential function of the job. That's a marginal function of the job. The job exists for data entry, right? So the accommodation is to allow them to perform those essential functions that still meet your production standards and your quality standards, or the accommodation enables them to, enjoy the benefits of employment. Let's say you have a break room, available to people, and if someone who's using a wheelchair can't get into that, then, you would need to find a way to make it where they can enjoy those benefits as well, right? And we always say, try to keep that interactive process informal and not legalistic. It's that back and forth. I need an accommodation. What about your job is in conflict? What about your medical impairment and your job is in conflict? If the need for the accommodation is apparent, you don't spend time getting medical documentation. If somebody says, you know, I use a wheelchair and I don't have access to this room, you do not then begin the process of getting medical documentation to show the person truly uses the wheelchair. You can see they are in the wheelchair, right? But a lot of disabilities are hidden. A lot of people have disabilities that people don't know they have. And if you need to get information about that particular situation and how it affects, them doing the essential functions of their job, you can certainly obtain that. You can't get their whole medical history. You can only get that's in question. But don't delay the interactive process. Sometimes there is a delay if you're waiting on medical records. Keep the employee informed. You may offer a temporary accommodation until you can get all that information together, but it should be that working together back and forth. Here's some best practices for reasonable accommodation. Have your accommodation policy and let people know about it. Uh, Recognize those requests for reasonable accommodation. Review the request individually, discuss the request with the applicant or the employee, obtain additional information if you need it. Look at alternative accommodations. If what you come up with originally doesn't work, look at alternatives. Reach out to the Job Accommodation Network if you need that assistance. And keep in mind that an accommodation you grant might work, but that doesn't mean that additional accommodation requests won't be forthcoming. A person can end up maybe needing an accommodation for something else, so consider those additional requests. Provide that effective accommodation and don't assume you can't afford to provide the accommodation. There are a number of tax credits, there are a number of places that assist with accommodations. And again, ask for help at that Job Accommodation Network. There's their website address. Disability-related questions and medical exams. We still see a significant number of cases in this area. So what the law says is you have there's three different stages, and the rules change for each stage as to whether or not you can ask any type of question that is likely to elicit information about a disability or perform a medical exam. So let's look at those three areas. We talk about pre-offer. That's before you have made a bona fide job offer to someone. They're in the application process. You may be interviewing, considering, but they have not been made a job offer. Strict limitations on when you can ask job applicants to answer any disability-related questions or take a medical exam or identify disability. You can't do it, right? Um, it changes when you make a bona fide offer of employment. you are allowed to condition a job offer on them answering those questions or successfully passing a medical exam as long as you require everyone in that same type of job to do that. So you can't pick and choose. Let me go back to the example of an individual with a limp, okay? And if you have made them a bona fide offer of employment, but you only want them to take a medical exam to make sure they're okay to do their job and no one else who enters in that job category, then you violated the ADA. So it has to be everybody or nobody, right? Okay, on the post offer. And it changes again once they become your employee. Once they're on the payroll, the rules change again. Um, you can only ask disability-related questions or require a medical exam if you need medical documentation to support their request for an accommodation, or if you believe they're not able to perform a job successfully or safely because of a medical condition. You may have a situation where someone maybe has a seizure on the job, has a couple of seizures, and you're concerned that, you know, the position they're currently working in, there may be some conflict with them having seizures and working on this piece of equipment or whatever. You can then do those medical exams in that situation. Or, obviously, if you are the person has a workers' comp injury, medical exams can occur, okay, for cause. But you can't just randomly say, hey, I want to give you a medical exam, or hey, I need to ask you these questions, okay? You can always randomly screen for drug use. Drug use is, drug tests you can do, but you cannot randomly screen for alcohol tests unless there's another federal law that requires it. Someone with the CDL, Department of Transportation, requires, I believe, a minimum of 2 alcohol tests randomly each year. We don't say that's a violation if you follow another federal agency's laws. But if you do random drug screening, you can't do random alcohol screening, just as a general practice. Alcohol screening is considered a medical exam, unless it's for cause. The person has the smell of alcohol on them, the person is acting inebriated at work, or the person has had a workers' comp injury. Then they are frequently, or had an injury on the job. Then, most carriers require you to test for drug and alcohol in that situation. That would be for cause. We have a ton of resources for disability related issues, and I've provided that link here. All of our guidance, Q&A documents, everything, sometimes even, we have mental health. I mean, we have a ton of things that you can go look at on disability discrimination. Anything we've done in the past 15 years is written in really pretty good, English. It's not all legalistic, and so it's generally pretty easy to follow. So there's that. Religious discrimination is an area where we see rising. We see the number of charges we're getting alleging discrimination based on religion going up. So that involves treating a person, an applicant or an employee, differently because of his or her religious beliefs or lack thereof. Not believing is also covered. The law protects individuals who belong to traditionally organized religions such as Buddhism, Christianity, Islam, Judaism, but also others who belong to religions, that we may have never heard of, as long as they have a sincerely held belief that, is equal to religious, ethical, or moral beliefs, okay? Or a lack of. They can have no beliefs about religion. And it can also involve treating someone differently because that person is married to or associated with an individual of a particular religion. Now, just like the disability law, the laws concerning religious discrimination have a component of requiring an accommodation. The law requires an employer to reasonably accommodate an employee's religious beliefs or practices unless doing so would cause more than a minimal burden on the operation of the employer's business. So under the disability, we said you had to show an undue hardship, which is a higher standard to meet than under religious accommodation. Religious accommodation, the law says more than de minimis cost, meaning more than a minimal burden on the operation of the employer's business. Example, someone observes a Sabbath and they want the Friday sundown to Saturday sundown. They want never be assigned shift work during that time, and ordinarily they would be. Um, if that would require the employer to pay overtime or to hire additional people, then that would be more than a minimal burden on the operation of the employer's business. Okay. Um, Example of some common religious accommodations we see: flexible scheduling, voluntary shift substitutions or swaps, job reassignment, modification of workplace policies or practices. Those are common. We also see a lot of religious accommodation requests surrounding religious garb. Maybe someone is required to wear a skirt. They're not allowed to wear pants. Maybe their religion you know, requires them to wear a headdress of some sort. And they're requesting that maybe modify a workplace dress code policy or something like that. So we do see a lot of that. We have a ton of resources on that, including new guidance that was issued last year on religious discrimination. Okay. All of our statutes that we enforce prohibit retaliation. Retaliation is the most frequently filed charge with the EEOC. Well over 55% of the charges filed with us have an allegation of retaliation. And what that is where an employer has penalized, punished, or denied an employee an employment benefit to someone because that person either opposed discrimination or participated in any way in a discrimination proceeding, an investigation, or litigation of a charge. Here's some examples that we see. Someone has engaged in the EEO process. Maybe they have complained to a supervisor or reported to HR that they feel that they are being discriminated against. Okay. Harassment and intimidation because someone has reported or participated or opposed. We see sometimes individuals being denied employment benefits, discharged, disciplined, demotion, reassignment. Sometimes they're given unfair evaluations in retaliation for their participation or opposition of discrimination. Acceleration of disciplinary actions, negative reference. I think I mentioned this earlier, of a former employee in retaliation for his or her opposition to discrimination or participation, and that contesting of unemployment compensation because someone complained of discrimination or participated in the EEO process. As usual, we have a lot of information and good tips for employers on retaliation. COVID-19 and EEO laws. Our response to the COVID-19 pandemic was immediate. We, like many employers, sent all of our employees home, 100% telework in March of 2020. Return to work is in process now across the country. It was delayed in Nashville and Little Rock because of air quality testing that had to be done in the buildings our offices are located in. But we're good to go. Memphis has already returned to work a few days a week, and then our employees in Little Rock return in a couple of weeks. They will start coming in a couple of days a week. One of the things that was interesting when we pivoted to 100% telework, and I'm sure other employers have experienced this too, is jobs that our agency previously said could not be performed via telework. Everybody teleworked, and the work still got done. In fact, production went up. We were still able to serve the public in a timely and efficient manner. We were still able to take charges. We were still able to conduct mediations. And in fact, a report came out just this week that virtual mediations were so successful, and participants loved doing virtual mediations, that we're going to continue to offer virtual mediations even when we are fully back into the office. So that's how, they were so successful, and it made it easy. People didn't have to travel. They could do these mediations from wherever. So we continued to serve the public in a timely and efficient manner. We continued to do outreach. We just had to do it virtually. And we issued guidance and updates on the COVID-19 and EEO laws, and everything is contained in one location on our website, eeoc.gov/coronavirus. I The minute all of this happened, we just were inundated. I'm small business liaison technical assistance person, so employers can call me with any questions they have. And we spent a significant portion of our time daily answering questions about COVID-19 and the EEO laws and certain things in the workplace. And how do you handle this? And how do you handle that? We have a great What You Should Know document. It is updated regularly. Um, One of the things that I get, and I wanted to mention it, one of the things I get asked frequently now is, can an employer, have a vaccine mandate? Yes, an employer can have a vaccine mandate, but the law still requires that the employer go through that process. If someone requests an accommodation because of religion or disability, they still have to follow, those rules and go through those on a case-by-case basis. Can they accommodate that individual's religious beliefs or that individual's disability and not having a vaccine? So that's still a thing we get a lot of questions about, and our guidance has great information on that. So our chair is Charlotte Burrows, and chairs will put out priorities, things they are focusing on, what we are going to kind of laser focus. If we get a charge in this area, these are things we're focusing our outreach and education on. These are things we're really looking at. Some of them are guided by executive orders from the White House, and others are just identified by the chair. These are issues we're seeing, and this is what we need to focus on. Okay, so these are the current chair's current priorities. Pay equity. So despite the fact that it's been more than 50 years since the Equal Pay Act and Title VII, prohibited unequal wages, significant unjust pay disparities still exist. And we know that women, on average, earn 82% on the dollar that men work. But that gap is even wider for women of color, Native Americans, Indigenous women, immigrants, people with disabilities. That gap is wider than the 82 cents on the dollar. And we know that not all pay disparities are the result of discriminatory actions, right? But we also know that discriminations in hiring, job segregations, promotions, those types of things contribute to that problem. So we focus on, when we get any charges with an allegation of wage disparity, we focus on those compensation systems and practices that discriminate on any basis, whether it be race, whether it be sex, whether it be age, disability, whatever that wage disparity can be based on. We really examine those compensation systems. Racial justice and systemic discrimination, including harassment. EEOC has had systemic discrimination as a priority for years. And what that is, systemic discrimination means it's discrimination that occurs regularly in the operations of an organization as an inherent part of that organization, through their practices and their policies that create a disadvantage for people with certain protected characteristics. For example, maybe their race or their sex or their age or their disability or their national origin. It could be any of those. And EEOC continues to play a large role in promoting racial justice and equity as the primary federal agency that enforces the laws against employment discrimination. We focus on systemic discrimination in all forms and bases. It's not just race. We look at systemic discrimination in all forms and bases. And we include, but not limit, racial and sexual harassment. Those are areas that we continue to see significant egregious cases in. So that's one of our priorities. Civil rights and the impact of the pandemic is another one. COVID was not only a public health crisis and economic crisis, but it was a civil rights crisis as well. COVID-19 and the economic fallout has disproportionately impacted people of color, women, older workers, and individuals with disabilities. So we are really focusing a lot in that area. Retaliation, as I said, it's the most frequently filed charge. It's a huge priority for us. Um, if you go to our website, our newsroom, every time we file a lawsuit, we do a press release and it's in our newsroom. Every time we settle that or win that lawsuit, we do another press release. And so you can find that and you can go through and you can see harassment and retaliation are significant portion of our litigation, along with reasonable accommodation under disability. But retaliation continues to be a huge problem, and we have seen time and time again where an individual may file a charge with us that is lukewarm at best, um, but the employer takes action against them because they filed the charge, and suddenly there's a red hot retaliation claim. So we focus a lot and give priority to retaliation. Another area that we are really looking at is the biases in employment that arise from the use of those algorithms and artificial intelligence systems. A lot of them are used in hiring, so we know that, we say the fair use of AI and algorithms falls squarely within EEOC's priorities to address systemic discrimination because it's part of that policy and practice of an organization that results in discrimination. And we just issued guidance last week on the fair use of AI and algorithms as it relates to individuals with disabilities. So you can go to our website and look that up. And, we just issued that last week. And there will be more guidance coming on the fair use of algorithms and AI. And then, of course, sexual orientation and gender identity discrimination is a priority for the agency. We look at those cases very closely. In June of 2020, the Supreme Court ruled in the Bostock-Clayton County case, which was actually 3 cases combined into one, that firing an employee because of their sexual orientation or their transgender status, gender identity, violated Title VII. So we are focusing our areas on that, our outreach, our education. We are currently putting together documents for the public. We call it SOGI, Sexual Orientation, Gender Identity. We have a dedicated landing page on our website that contains all of our resources there. So if you have any questions regarding that, you can go in for our website, type in sexual orientation, gender identity, and it will take you to that page. We also have a couple of initiatives that we're working on. We have a Youth at Work initiative where we want to educate our youth workers, typically age 15 to 19, about their rights and responsibilities in the workplace. And it came about primarily because of the startling and disturbing number of cases of egregious sexual harassment against teen workers that we started receiving. So we also have a Youth at Work webpage. You can go to our main page and you can see the link to it. And it's geared towards, educating children, young workers about their rights and responsibilities. And we love to do outreach with our young people. So if you have a youth group or a school or any type of youth organization and you want us to come talk to those young workers about their rights and responsibilities, we are available to do so. If you are required to file EEO-1 2021 component data, the deadline was extended again to June 21st. If you are a filer, we have a dedicated EEO-1 component 1 website at eeocdata.org/EEO-1. And it has the online filing system, the updates, and all the resource materials. And if you need assistance on it, there is a link to contact someone for assistance. We still are getting a number of questions on EEO-1, and basically the component data, this is the first time the agency is collecting the component data. So we really are unable to assist at the local level, and so we have to refer people to that contact us site to get assistance. Outreach and education, obviously we do no cost outreach events were available. I don't know who will be replacing me, but until July 28th, I'm available. After that, there will be someone who will be doing this. We have fee-based events. We have 2 virtual workshops coming up, July 13th and July 27th. We will be opening those for registration next week, and we'll push out information on those. They're going to be 3-hour workshops, and we do seek HRCI and SHRM and CLE credits for our workshops. And then we do what we call customer-specific training, and that's where an organization contracts with us to do a specific type of training. They may want training on, EEO 101 for their managers. They may want training on reasonable accommodation process. They may want workplace harassment training, or whatever the case may be. And so that you can contact me if you have any of those needs for that. And if there's any questions, I'm happy to take them. Or if you want to reach out to me after, sometimes people don't want to ask certain questions, and that's fine. You can certainly email me or call me, and I'll be happy to help you too.
Well, we try to keep these to an hour, so we have about 3 minutes left. If anybody wants to pop anything in the chat, that was a wonderful presentation, chock full of information. I feel like we all learned a lot, and appreciate your time so much. There is one question already that I'm going to ask it real quickly. Our affirmative action plan requires a voluntary self-identification form as part of the application packet. This form has options to answer yes, I have a disability, no, I do, no, I don't, or choose not to answer. Is this a conflict with the slide information for pre-offer? Is this okay?
If that information is separate from the application and not maintained with the application. So AAPs, affirmative action plans, usually require that. That's part of it. As long as it's a separate, tear off thing or something that's not kept with the application, it's fine.
Okay, thank you. We had some other positive feedback, great presentation. Thank you for the insight, things of that nature. That was the only question we had.
Okay.
Since we are running tight on time, I just want to ask that if anybody has any additional questions, to make sure to drop an email to you, or they can send those to us, either one, and we'll make sure to get those answered for them. Thank you, Deborah, and thank you to all our attendees.
Thank you. You all have a wonderful weekend.
You too. Bye-bye.
Bye-bye.